felony assault, burglary by habitation, and now a failure to ID.
Your Honor, we have a case that's not on docket today, but she's got a warrant. They filed on her last month for a case that happened in August, and she wanted to turn herself in.
Wait, did you catch that? This isn't even on today's docket. She walked in to surrender herself. That could play big in her favor or backfire, depending on what the judge thinks of her record.
Case number is 2553 536. Brianna Beck.
You are Brianna Beck.
Yes.
Ms. Beck, you are now charged with theft. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Judge, can I get the case number, please?
255-3536.
3536?
Ready?
Yes. On December 17th, 2024, an officer reviewed an offense report of a theft on September 17th, 2024. According to the report, the complainant reported that the defendant, known to the complainant by name and site, stole 2 espresso machines on August 9th, 2024. The complainant stated the defendant committed the theft at 3 other store locations. The officer reviewed documents that there were theft incidents at 4 home goods locations. The first incident occurred outside of Harris County, Texas. The second incident was investigated by the Harris County Precinct 4 Constable's Office. The third incident occurred on August 9th, 2024, where the defendant and an unidentified female entered the home goods and entered the line to make a merchandise return. Once in line, the defendant ran toward the back, where she selected 3 sets of sheets and then walked to the front of the store and rejoined the female in line. The defendant then placed the sheets on the counter and provided the cashier with her state ID. The system denied the non-receipted refund due to excessive returns without a receipt.
That's nearly $1,600 in stolen goods in one day, across multiple stores, and she used her real ID bold. Or just sloppy.
The merchandise was then returned to the defendant. The defendant and the unidentified female then left the store, passing all points of sale without attempting to pay. The value was $599.99. The fourth incident occurred on August 9th, 2024. The defendant arrived alone at another home goods location and proceeded into the store with an empty shopping cart. The defendant selected 2 espresso machines and then walked to the front of the store and passed all points of sale without attempting to pay, and the security sensors went off. The value was $999.98. The officer reviewed the surveillance footage from the third and fourth incidents and compared them to the defendant's previous booking photo, and they were a match.
All Marshall's Home Goods? Is that what it is?
Yeah.
Okay. She's on bond for a theft. She's on bond for a gun case with us now. Where is the first theft?
The first theft is from a Walmart judge. $121.
Ms. Beck, I'm going to find that there's probable cause to go forward with the case, and I'm going to tell you now.
A $$50,000 bond warning, and the judge is clearly done playing games. You can hear the shift. This isn't a lecture, it's a last chance.
I will do everything in my power to protect every person, place, thing in this county. And if I have to put you in custody and make your bond $50,000 because you continue to become a danger to our city, I will do it in a heartbeat. Do you understand me? I'm ordering you not to go to any Walmart, any Marshall's Home Goods, in anywhere. And I'm going to put a GPS monitor on you so I know where you are at all times. You are not to consume alcohol or illegal drugs. And I'm sending you now for a test so I know what, if anything, is in your system. You're to test, and then...
She's not just a defendant, she's also a complainant in another assault case. That complicates things. Multiple roles in the courtroom always muddy the waters.
You're to come right back. Do you understand?
Yes, sir.
Do you have a job at this time?
Yep.
What do you do for a living?
I'm a reservationist.
Okay, I want proof that you have a full-time job because that is now a condition of your bond as well. I want to make sure that you're working full-time as well.
And Your Honor, the defendant is also a complainant in this court as well. I need to bring up, we've reassigned these cases so that we can deal with it, and so it's on separate prosecutors. Like, I have the other defendant's case assigned to me, and Abigail is assigned this case. She's listed as so she is listed as the complainant in a separate case also in Court 5.
In what regard?
So she,
Like in an assault or something like this, of this nature?
yes, it's an assault, Your Honor. And to.
Okay, so you got, I mean, you divvy it up how you want.
Yes.
Is that I don't want her to pick up fourth case.
Right.
No, we just want to
Sure,
make you aware, Your Honor.
Yes.
I'm also ordering you not to be in possession of any weapons. Do you understand? These are your bond conditions.
Notice the strategic move here. Defense tries to frame her surrender as a sign of good faith. But the judge is weighing behavior against history. Smart play, but will it land?
If you violate these conditions, I'm going to revoke all of your bonds and I don't understand why you're having attitude. You have now 3 cases. You're rolling your eyes as if you have some kind of, we need to talk about bond. What do you suggest as far as a bond in this case, in the newest theft case?
We would suggest a surety bond on the case, Judge, and leave it up to your discretion in terms of amount, but I don't think a PR bond would be appropriate here.
Well, if you do make it a surety bond, we could ask for it to be low. She did show up here on her own.
This is one of those rare court moments where tough love meets strategy. The judge is sending her for testing immediately, and the PR bond is a chess move to make it happen.
Volition today. And I think she's at least for today showing the right attitude about how to handle this from here on in.
Set your bond at $2,500. Cash surety. No more PR bonds. Do you understand? I want to send her for a drug test right now. So Felicia,
Judge, I can't send her until the bond has been posted, or else they'll take her into custody.
okay, then I'm going to give her a PR bond for now because I want to send her right now.
Yes, Judge. I'll still have to wait till the trial starts.
Yep, go for it. Okay, I'm going to set the bond at $2,500. I'm going to give her a PR bond because I want to send her for a test now. You were to test and then you're to come back. Do you understand?
Yes, sir.
Not leave until you sign our bond conditions. Please take a seat.
Do I have to be back here when she returns?
No, I'm not. I want to know what, if anything, is in her system, but I want proof within a week of today of full-time employment. Okay. And then depending on what happens with the test, when we come back in a week, we'll talk about how to go further. Okay. Thanks. Sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
I'm sorry, Your Honor, I think I got the wrong cause number.
It's 2-555-746.
On March 15th, 2025, at approximately 2:15 a.m., the officer observed the defendant's vehicle failing to maintain a single lane of traffic. They also observed the vehicle to signal a lane change, failed to signal a lane change multiple times. A traffic stop was then conducted. The vehicle pulled over and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed a strong odor of alcohol on the defendant's breath and person. The officer then had the defendant step out, and they observed the defendant to have red, glassy eyes and be unsteady on his feet. The defendant stated that he had 1 beer at a friend's house. The officer conducted SFSTs on scene. 6 out of 6 clues were observed on the HGN. 4 out of 8 clues were observed on the walk and turn, and 1 out of 4 clues were observed on the one-leg stand. The DIC was read to the defendant, and the defendant consented to provide a breath specimen. The results were .136 and .139.
What was the stop for again?
The stop was at 2:15 in the morning. He was failing to maintain a single lane of traffic, and then he also failed to signal a lane change multiple times.
All right, Mr. Turribiates, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run him to see if he has any prior DWIs, please, and a license?
He does have a license and insurance, Your Honor, no prior history.
No prior DWIs.
All right. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, your bond will be revoked. You will go to jail. No more PR bonds. Do you understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel, and he'll tell you if and when you have to come back to court. If he tells me he can't get a hold of you, you pick up a new case, you drive without a license, or it's not going to go well. Do you understand?
Yes, sir.
Okay. I'll have you sign a receipt of Victoria. You'll get with Felicia for your bond conditions, and you guys are free to go.
Thank you, Your Honor.
Thanks.
Can I have your shoes?
Take care.
Morning, Judge.
Good morning. How's it going?
Good. How are you doing? Yeah. I have David Duran on the docket,
Okay.
and if the court has the time, I'd like to address the probable cause.
Okay. Absolutely. Of course. Are you ready?
Yes.
Okay. Please.
On January 11, 2025, an officer was on patrol and observed the odor of marijuana and a male to be smoking in a motor vehicle nearby the 8,700 block of Lazy Brook Lane. The officer activated his emergency lights and positioned himself behind the motor vehicle and made contact with the defendant. The officer had the defendant step out of the motor vehicle and advised the defendant that he had been observed smoking marijuana. The defendant stated he was smoking marijuana inside the motor vehicle because he did not want to smoke inside his friend's home. The officer observed the strong odor of marijuana. A probable cause search was conducted of the motor vehicle, and the officer observed small crumbs of a green leafy substance known to be marijuana based on training and experience at the bottom of the center console of 0.37 grams and a small marijuana joint in the ashtray of the cup holder. The officer observed an unholstered black Glock handgun laying in plain view on the back seat floor. The defendant stated the handgun belonged to him.
So the way she's read it, there is probable cause. However, the way I read the DIMS, the officer initiates his lights first and then approaches the vehicle, sees him smoking, observes the odor, and then, so I think he's made the...
If that was right, yeah. But the way that she read it, and perhaps maybe you saw something different. I don't know.
Reading the DA's summary of it, I don't think she actually read the DIMS version, which is what I read.
Oh, I can read directly from the DIMS if you would like me to, Judge.
Maybe I think you should, because the way I read it, it was the stop first and then the observation that he's smoking marijuana.
I'll read the DIMS.
Well, but nevertheless, I mean, is that what happened?
So I'm looking at it right now, and I'm seeing that the vehicle was observed to be parked on the public roadway. He observed the male, he observed a male sitting in the vehicle, and it was parked on a public roadway. Upon observing the male, he positioned himself behind the vehicle to make contact with him upon approaching the vehicle.
And then initiated his lights.
Yes, he activated his lights before he positioned himself behind the vehicle.
I mean, sometimes they're incomplete, you know?
Yeah, the way I read it, he puts his lights on, gets behind the car, approaches him, sees him smoking, and then...
I mean, right, you can't put the cart ahead of the horse, but I mean, in that instance, I think that if he sees him smoking, right?
Yes, Judge, and I think the issue...
Smells it.
My argument is that he sees him smoking and smells it after he's been detained. He's not free to leave at that point because he's positioned his car behind the vehicle, put his lights on, he's detained.
I don't know. From what she read, I think there's probably.
Yeah, and in the first sentence, it says that he observed the smell of marijuana and the male to be smoking in the vehicle nearby.
Maybe we can look at the video and see how it reads.
Okay.
Do it.
Okay.
Take a look at the video. You see something different, you can always come back to
Sure.
it. And I'm always willing to see it again.
Okay, thank you for doing that, Judge. Appreciate it.
Yeah.